I have that it is noon. Lance, Norman, you okay if we get started?
Yes, ma'am.
Great. Good afternoon, everyone. Thank you all for being here. Welcome to the second and our third welcome to the second of our three series, special asset summer school series. This session will cover a topic on the North Carolina Commercial Receivership Act and involuntary bankruptcy. I'm Haley Upton, the marketing coordinator of events from proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try and troubleshoot with you. Our speakers are happy to take questions after this webinar. So at the end, if you have a question, please type it in the Q&A box that will be on your screen and we will address it at the conclusion of the presentation. I'm going to go ahead and turn it over to Lance so that we can begin.
Thank you, Haley. Good afternoon, everybody, and thank you for joining us. My name is Lance Martin, and I'm joined by my colleague, Norman Leonard. He and I both practice creditor rights and bankruptcy and workout and insolvency here at Ward & Smith. I've been doing this for 23 years, and Norman's been doing it for about half the time. And so we're glad you took time out to join us today for what should be a very entertaining 6 to 8 hour presentation with no breaks. Norman and I, about a year ago, got involved in what we believe to be the first general receivership under the new North Carolina Commercial Receivership Act. In that representation over the past year, we've been able to think a lot about the new Receivership Act, involuntary bankruptcy, regular bankruptcy, issues, challenges, opportunities for bank officers. And so that was the genesis behind today's presentation. So we want to cover two topics for you, and that is involuntary bankruptcy and receivership. And we're going to do that with the assumption that you are not lawyers, that you are special assets officers, bankers, lenders, business executives. And so because you're not lawyers, you are rational actors. And what I mean by that is that we're going to assume that you want to recover as much as possible from your borrower for as little additional investment, both time and expense, as possible, and while minimizing risk to your organization. And so I should start by saying that the bottom line is that involuntary bankruptcy and receivership are extreme remedies. You're going to be attempting to wrest control of a business from its owners. That's going to cause them public embarrassment. It's going to wreck their credit standing. And as a consequence, this is not something and should not be the first thing you think about when your borrower is in default. You have sort of the normal arrows in your quiver: collection, foreclosure, repossession, forbearance, settlement. These are your first options. Think of involuntary bankruptcy and receivership as your weapons of last resort. Particularly in the case of involuntary bankruptcy, it's kind of like Bigfoot. We all know he exists, but very few of us have seen him. Less than 1%, I think less than 1/10 of 1% of all bankruptcy cases are commenced as an involuntary case. Having said that, here are some situations where you might want to consider either an involuntary case or a receivership. You've got an operating business that's going to be worth more sold as a going concern than liquidated. You have a situation where your borrower is not cooperating with you. It's impossible for you to get accurate information and disclosures about their financial condition. You have reason to believe that there is corporate waste, fraud, abuse, mismanagement going on inside of a business that, but for that, could be profitable, or at least profitable enough to get you out of your lending relationship. Along with that, there could be a variety of breaches of fiduciary duties by officers and directors. You may have wind of fraudulent transfers, misappropriation of funds, or if it's not the borrower's actions, you might have a situation where you've got litigation and collection by other creditors against your borrower, and you're fearful that you're going to be they're going to pick the bones clean, and there's going to be nothing left for you. Maybe it's a race at a courthouse, and they started the race 6 months ago. So this is kind of the scenario where you might want to consider one of these two options, because they can preserve assets from further dissipation. They can maximize sale value of a business as a going concern, and they can provide for an orderly liquidation of the business and ensure equality of distribution of a debtor's assets, as opposed to creditor on creditor violence over a diminishing pool of assets. Here's the spoiler alert. From a cost benefit analysis, you will rarely do better in an involuntary case or a receivership than you would do using your traditional weapons of foreclosure, repossession, collection, forbearance, settlement. These remedies are probably better used as a threat than actually carrying it out. In fact, I would go so far to say that rather than you spending $10,000 on a retainer for Norman and I to file an involuntary case for you, your money would be better spent giving $10,000 to your lead special assets officer as a buy-in to a poker tournament where he or she can hone their bluffing skills. So you can bluff your borrower into settling up with you, giving you the information you need, or filing a voluntary Chapter 11 or Chapter 7 case, and then you go in as a creditor in the bankruptcy case. As between the two, if you must, receivership is going to be much less risky, particularly under the new act. With an involuntary bankruptcy, if you lose, instead of collecting money, you're going to end up paying it to your borrower and your borrower's lawyers. The other thing is that if you file an involuntary bankruptcy case or a Receivership Act, you can expect a fruit basket at Christmas from your lawyers, because you are inviting plenty of litigation. With involuntary bankruptcy, even if you succeed, you get no gold star, you get no special treatment from the bankruptcy judge. Even though you're going to take all the risk and expense, which I'll get into in a minute, you're going to be treated just like any other creditor. So if you're an unsecured creditor, you're going to receive distributions from a trustee pro rata with all the other unsecured creditors. And if any of you have filed an unsecured claim in a Chapter 7 case or even a Chapter 11 case, you know what that translates to. It's usually pennies on the dollar in 90% of the cases. So that's all the disclaimers. But if you like me, like maybe you've seen these. There's always in the heist movies. There's always, they're talking about whether they're going to rob the bank or not. And there's, they come up with a plan and somebody says, this plan is crazy. And then there's somebody else that says, yes, but it's so crazy, it just might work. So, I mean, if your boss is saying, we want to do this, here's what happens with involuntary bankruptcy. Here's how you commence a case when you can, when you can't. So I'm going to run through all that, and then I'm going to turn it over to Norman, who's going to talk about the Receivership Act. 3 requirements to bring an involuntary bankruptcy. 1, you need 3 or more petitioning creditors if the debts or if 3 or more petitioning creditors. Each creditor has to hold a claim against the debtor that's not contingent as to liability or not the subject of a bona fide dispute. And the claims must aggregate at least $15,775. So pretty low threshold. If a debtor has fewer than 12 creditors, then 1 unsecured creditor can file an involuntary case. Under the same standards, you have to have at least $15,775. No one should ever file an involuntary case if their claim is only $15,000. No one, you need to move the decimal over. I would say even $157,000 wouldn't be enough. $1.57 million might be enough for you to consider this. If the debtor disputes the filing of the involuntary petition, the court is going to have to make a determination as to whether the debtor is generally not paying its debts as they become due. Okay, so those are the 3 requirements. Let's take them in order. Number 1 is numerosity. 3 petitioning creditors. 3, that's the magic number. That sounds pretty simple. We just do the math, 1, 2, and 3. The key point here is they have to be separate claims. So joint holders of an obligation are counted as 1 creditor. So I guess where that may come up is that if you're part of a participation loan with a couple other lending institutions, and that loan is in default and you're considering an involuntary, those 3 banks would be considered 1 creditor, not 3. So you would have to find other creditors on board. From a practical standpoint, to get your other creditors on board, you've got to find them and you've got to contact them. So, do you know who they are? If you do, are you prepared to share your information with them to try to get them on board? You need to watch what you say when you communicate with these people or with their attorneys, because communications are not going to be privileged. You're exposing yourself and your collection situation to them, which could put you at a disadvantage if they reject your overtures and have no interest in filing the involuntary with you. And really, there's nothing to stop them from telling the borrower what you're up to or using the information to their advantage. Step 1, you need to get 2 other people on board to file the case if the debtor has 12 or more creditors. The claim can't be contingent. A contingent claim is like a guarantee agreement. The guarantor is on the hook if the primary obligor defaults. Until the primary obligor defaults, claim isn't contingent. That would rarely come up for banks and lending institutions, because you would have a monetary default before you were considering this. The third is the claim can't be the subject of a bona fide dispute. Bona fide dispute can be as to the liability on a claim or the amount of a claim. There's a question in North Carolina where some courts in the United States adopt what's called the all or nothing approach. So meaning if any portion of the claim is subject to a bona fide dispute, petitioning creditor is automatically disqualified. Other courts say that a claim can be partially disputed without impacting eligibility. It's undecided in North Carolina, but you can be sure that if you file a claim and you have this issue, the debtor's going to find all the bad cases in the United States and try to shove them down your throat. So bona fide dispute, some examples that I can think of is, say you filed an involuntary case based on a covenant default, which you should never do, and there's some dispute as to interpretation of the covenant default, and they've got an argument that they didn't breach it, or that you didn't give them the appropriate cure time or notice. Allegations that they are not in default because a bank officer granted them a concession. Counterclaims could give rise to a bona fide dispute. On the issue of amount, for most loans, calculating the amount should not be an issue. I could see this arising in accounts receivable financing or factoring, where sometimes the calculation of a payoff can be quite complex given the activity in and out of an account. And so if that's your situation, you would want to be rock solid on your ability to establish that the amount you're owed and that there's no question as to that amount. The dollar amount, we talked about that, $15,000 and change. We are talking about unsecured debt of $15,000 or more. Oh, sorry about that. If you have secured debt, just go seize your collateral and first and deal with that, and then consider other alternatives. The generally not paying debts as they become due test, again, seems pretty straightforward, but there are cases across the country that say if the debtor's not paying you, but the debtor's paying everybody else, then you might be in trouble and you might not be entitled to an involuntary bankruptcy. So the court's going to look at the totality of the circumstances. So the number of debts unpaid each month relative to those paid, the amount of the delinquency, the materiality of the non-payment, etc. So just because the debtor is not paying you doesn't necessarily mean that the debtor is not paying all of its other debts and that you're automatically entitled to proceed with an involuntary bankruptcy. So say you meet all three tests, and you file the case, you're safe, right? Well, actually, you're still not safe, because there are cases in the United States that say that even if you meet the statutory requirements, you can still get dinged for what's called a bad faith case, and the case can be dismissed. So, so here again, the court will look at the totality of the circumstances if the debtor raises this as a defense. And so some of the things they're going to look at is, was the filing motivated by ill will or desire to harass? Did the petitioning creditor file to obtain a disproportionate advantage for themselves, or a tactical advantage? Was it used as a substitute for customary debt collection procedures? Was the timing suspicious? Are you suing your debtor and he's counterclaimed and he's noticed the deposition of the president of the bank, and the day before the deposition you file your involuntary bankruptcy? That's suspicious timing. How does the court figure all this out, this totality of the circumstances stuff? Witness testimony and credibility. And that means that all the deciders at the bank are going to be deposed, and they're all going to have to come and testify at trial. Remember, attorney-client communications are privileged. Communications internally in the bank before your lawyer got involved or not, communications with other creditors or not. It only takes one email where someone makes a disparaging remark about the borrower, or a comment like, we need to get him, our objective here is to get him out of the bank, to put the bank at risk. Bankruptcy is collective cruelty. That's what we refer to it as, collective cruelty. So the idea is that all the creditors are going to share in the loss, and we're not going to treat anybody special. So if that's the situation, then involuntary bankruptcy may work if everybody's on board with it. But if it's just you going alone, or you and just a couple of creditors going alone, the court is going to scrutinize it with care. It's a high stakes venture. If you lose, if the court dismisses the case, the retribution is going to be biblical. The court has the authority to award the debtor attorney's fees and costs if they dismiss a case, and that includes fees incurred in defending and defeating the involuntary petition, fees incurred in prosecuting a claim for damages, and my favorite, fees on fees, which is fees incurred to collect the fees that the court awarded in the first place. So that should send a chill through all of you. So that's the lay of the land on involuntary bankruptcy. Again, it's a tool in the bankruptcy code that can be used, but it needs to be used sparingly. Now, if your regular collection efforts are inadequate for the situation and you need to take a more aggressive stance, the North Carolina Commercial Receivership Act may be a much better alternative for you than involuntary bankruptcy. And so that is going to be my segue to turn this over to Norman to take it from here.
All right. Thanks, Lance. As Lance mentioned, I'm just going to discuss the North Carolina Commercial Receivership Act, which is only about a year and a half old at this point. The act applies to business entities and to individuals whose business debts are at least 50% of their total indebtedness. The purpose of the new act is to provide a more comprehensive framework for receiverships in North Carolina than what existed before. Our previous statutes were very general in terms of substance and procedure, and they did not provide creditors or courts with much guidance. So the new act is quite extensive, and it's intended to provide creditors with more certainty and consistency in terms of what to expect when they pursue a receivership. Now, the act establishes two types of receiverships. There's a general receivership and a limited receivership. A limited receivership is a receivership that's based on the enforcement of a lien or security interest covering a discrete asset. For example, a creditor with a deed of trust and an assignment of rents on a piece of commercial property might seek the appointment of a receiver to take control of that property, to manage it, to collect the rents, and then to market it for sale. By contrast, a general receivership is where the receiver takes control of all the debtor's real and personal property, similar to what occurs in a Chapter 7 bankruptcy, and then either liquidates it or sells the debtor's business as a going concern for the benefit of the creditors. Now, obviously, a general receiver's power to manage and dispose of a debtor's property are going to be much more expansive than that of a limited receiver. But as we'll discuss in a minute, general receiverships also typically involve greater procedural burdens, greater expense, and increased scrutiny from both the court and the debtor's other creditors. The grounds for appointment of a receiver will vary depending on which kind of receivership is being requested. And it's important to keep in mind that the appointment of a receiver is always going to be at the discretion of the court. But generally speaking, a limited receiver can be appointed in connection with any proceeding to foreclose or enforce a security interest, so long as one of 4 criteria are met. Those criteria include cases where the loan documents expressly provide for receivership, where the creditor is undersecured, where the collateral is in danger of some waste or impairment, or if the debtor has simply failed to surrender collateral to the creditor that the creditor is entitled to repossess. Now, in the case of a general receivership, a general receiver can be appointed when a debtor is either insolvent or in imminent danger of insolvency, or if they're failing to pay their debts as they come due, or if their business is the subject of a dissolution proceeding. Now, in terms of procedure, creditors will usually be required to file their action to appoint a receiver and then give the debtor at least 10 days notice of the hearing at which the court will consider that request. Now, if there is a true emergency because the collateral is in danger of waste or some other harm, then the creditor can seek the appointment of a temporary receiver without notice to the debtor. If that happens, then the court will have a follow-up hearing as soon as possible to consider the appointment of a permanent receiver. It's the procedure is sort of similar to seeking a temporary restraining order versus a permanent injunction or preliminary injunction. Now, unlike the old receivership statutes, the new act provides mechanisms for the appointment of a single judge to oversee the receivership from the beginning to the end. Now, the goal here is that the creditor and receiver will not have to continuously re-educate judges about the history of the receivership and about the debtor as they cycle through the county where the receivership is pending. And this was a problem under the old act that the new act sought to remedy. And once a receiver is appointed, the act imposes some procedural requirements that are similar to bankruptcy proceedings in federal court. The extent of those requirements will depend on whether the receivership is a limited receivership covering a single asset, or whether it's a general receivership covering all the debtor's assets. For general receiverships, the receiver's notice and reporting requirements are going to be fairly substantial. The receiver will be required to thoroughly research the debtor's assets and liabilities, to provide written notice of the receivership to all of the debtor's other creditors within 30 days, and then to file schedules with the court detailing all the debtor's debts and property within 60 days. After that, the receiver will need to periodically file status reports and attend status hearings to update the court and the other creditors as the receivership progresses. To the extent these reporting obligations, to some extent, these reporting obligations are of course discretion. So the creditor and the receiver can seek to minimize them somewhat by court order. As the general receivership progresses, the receiver will need to protect and assemble the debtor's assets, to operate the debtor's business if it's still operating, and then to formulate a plan to either sell the debtor's business as a going concern or to liquidate it. Depending on whether there are going to be surplus proceeds after the secured creditors are all paid, the receiver will need to propose a process for creditors to file claims in the receivership, similar to the proof of claims process that you'll see in a bankruptcy. And as you might imagine, the costs of receivership are going to depend on the circumstances and the type of receivership involved. The cost of a limited receivership is likely to be relatively modest and predictable compared to that of a general receivership, because you're likely dealing with a single asset or a limited pool of assets rather than taking over a debtor's entire business and dealing with all their creditors. In contrast, the costs associated with a general receivership are going to be more substantial and more unpredictable. And there are a lot of factors that will contribute to those costs. For one thing, a general receiver is expected to remain independent from the creditor who sought their appointment. So that means that the receiver will need to hire their own counsel to provide them with legal advice, to represent them before the court, and to provide to prepare their notices and court filings as the receivership proceeds. Also, depending on the nature of the debtor's business, the receiver may need to hire accountants and other professionals to assist them in carrying out their duties. Also, the receiver may need to incur legal expenses to pursue litigation against third parties, to recover money that's owed to the debtor, or to defend the debtor in litigation to protect its assets. And all of these activities are going to generate substantial expense. Now, in theory, The receiver and any professionals retained to assist them and all of the other receivership expenses are supposed to be paid from receivership assets. But the creditor seeking the appointment of a general receiver needs to understand that they're unlikely to know whether the debtor's assets and income will be sufficient to cover these expenses. So they need to expect that the general receiver and the court will probably require them to provide a guarantee that they will pay the costs of the receivership if the debtor's assets are insufficient to cover it. Plus, any professional receiver worth hiring is probably going to want to be paid on a monthly or biweekly basis. So even if there's a sale of the debtor's assets at the very end and it's expected to pay the costs of the receivership in the long run, the creditor will very likely need to finance the receivership in the interim. All right, at the end of it all, when the receivership property has been disposed of and distributed and the receiver has completed all of their duties, the receiver is required to file and serve a final report of their activities and the proceeds and expenses of the receivership and the receiver's distributions to creditors. If no one objects to that final report and the court approves it, then the court will terminate the receivership and discharge the receiver from any further duties. Now, there are some noteworthy similarities and differences to a bankruptcy that bear mention. First, like bankruptcy, the Receivership Act provides for an automatic stay that prohibits most actions against receivership property. But accepted from this stay are creditors with rights of set-off against debtors' accounts and creditors with liens that have priority over the receiver's appointment. For general receiverships, there's also an additional automatic stay that will stay most actions and proceeding against the debtor itself. But unlike bankruptcy, this additional stay only applies for 60 days unless the receiver moves to extend it. Once this stay is expired, then actions against the debtor will move forward and the receiver is going to need to decide whether or not they are going to defend those actions on the debtor's behalf. A second similarity to bankruptcy is the potential for receivership financing. Like a debtor in bankruptcy, the receiver is permitted to obtain unsecured financing to fund the receivership. And if there are unencumbered assets, then the receiver can also obtain secured financing with court approval. But unlike bankruptcy, there is no ability for the creditor who provides receivership financing to get a lien on debtor property that is ahead of other pre-existing liens. As you might recall, such liens are called priming liens in the bankruptcy context, and these priming liens do not exist in receivership. Now, as I previously mentioned, it will probably be the case that the only potential source of financing is the creditor who actually sought the appointment of the receiver in the first place. Fortunately, the Act does provide that a creditor who extends unsecured financing to the receiver is at least entitled to some administrative priority for repayment ahead of unsecured creditors. But if there are no unencumbered proceeds of the receivership, then the creditor who extended unsecured financing will ultimately have to eat those expenses. A third similarity to bankruptcy is that there is a mechanism for the receiver to sell the debtor assets outside of the ordinary course of business, free and clear of liens. And the receiver can even do this over a secured creditor's objection so long as they meet certain criteria under the Act and get court approval. So those are some of the similarities to bankruptcy, but there are also some significant differences that we should mention. One major difference is jurisdiction. Compared to the nationwide jurisdiction of the federal bankruptcy court, the jurisdiction of the state court that is administrating the receivership is going to be limited to parties and proceedings located in North Carolina. So this means that a receivership is going to work best when the debtor's business and assets are mostly confined to the state of North Carolina. If a debtor is facing litigation and foreclosure in other states, then the receiver's ability to protect those receivership assets is going to be very limited. And the receiver will ultimately need to decide whether to hire local counsel in those other states to defend the debtor and its property. A second difference, if we're comparing receivership to regular Chapter 11 bankruptcy, is that there will be no unsecured creditors committee in a receivership. An unsecured creditors committee is sometimes viewed as a downside of Chapter 11 because the committee may use the debtor's assets to hire their own counsel and challenge the debtor's plans for reorganization. The burden and expense This burden and expense is absent in receivership. Unsecured creditors are allowed to appear in the receivership and they can file motions and objections to the receiver's actions, but if they do so, then they'll need to spend their own time and money to do it. The third major difference is that a receiver lacks the avoidance powers of a bankruptcy trustee. The receiver cannot seek to recover preferential payments or undo property transfers or avoid liens against debtor property like a bankruptcy trustee can. And in this area, a receiver's power is limited to pursuing claims for fraudulent transfers, just like any other creditor might under the North Carolina Avoidable Transactions Act. So if there are recent judgment liens or preferences that aren't voidable and they have prejudiced the position of the creditor who is considering action, then a bankruptcy may be the only way to effectively deal with those issues.
Thank you, Norman. I know we're running close on time or running out of time. One thing I wanted to mention before we get to questions is that the Commercial Receivership Act does, like, if you can't decide between bankruptcy and receivership, how about both? So a receiver does have authority under the act to put a business into bankruptcy, not an individual, but a business. So you, in theory, you could file a receivership action under the new act. And once you had a receiver in place, the receiver could then file either a Chapter 7, could file a Chapter 7 petition, and maybe even a Chapter 7 petition in bankruptcy to move everything into bankruptcy court. So we've never seen it done. The statute is young, so we don't have a body of case law surrounding these issues. And frankly, that's one of the advantages of being in bankruptcy as opposed to the Receivership Act, because the judges are familiar with the code and the cases interpreting it, whereas with the Receivership Act, everything is new. But that is a consideration, and that would give you the ability to operate under the code as you saw it, either a 363 sale as a going concern of the business, or a liquidation, the proof of claim process, avoidance actions, all the other issues that Norman hit on. So with that, Haley, do we have any questions? We've got about 8 minutes before we're going to cut everybody loose.
Yeah, we do have a question. So this one came in. Please address any specific concerns if you are an asset-based lender and take ownership of an asset, such as a receivable, and want to take dominion of the asset and do not want to be considered a quote-unquote creditor.
Yeah, so with asset-based lending, particularly with accounts receivable financing or factoring, this is a hot button issue in bankruptcy. So you want to be clear, and it's going to be driven by your loan documents. So your loan documents need to be absolutely clear on exactly what's going on. So if your borrower is selling you its receivables and you are taking ownership of the receivable as an owner, and you're paying X amount percentage, then that has to be explicit in your loan documents. I think where the people in asset-based lending get into trouble is that their loan documents want to have it both ways. They want to say that they are the owner of the receivable, but at the same time, if the account debtor doesn't pay, they want to be able to return the receivable to the borrower beyond collecting against the borrower if there isn't a payment. And so it looks like you're trying to have it both ways. One, you're taking ownership, but also that, no, it's just collateral. And what happens is there's a bankruptcy filing, the Chapter 7 trustee or debtor in possession are going to want to fight you on that issue if there's ambiguity in your loan documents and say, no, the receivables are ours, and you just have a security interest in them. So you're a secured creditor up to the value of the receivables. You're not the owner of the receivables. But yeah, that's a fight that you see with some frequency when companies who are under an accounts receivable financing or asset-based lending regime go into bankruptcy voluntarily. Any other questions, Haley?
Yeah, we have one more. And can a receiver put a company in bankruptcy?
Yes. The answer to that is yes. Correct, Norman?
Yes, the act specifically expressly states that the receiver has the authority to put the company into bankruptcy. So if the receiver gets in there and pops the hood on the company and it's looking like the receivership isn't going to be financially economically viable, then considering bankruptcy as an option is available. And I think that the weight of the legal authority out there also says that once a receiver is appointed, they take over the role of the company's management, and the authority of the company's former management to file bankruptcy on behalf of the company is removed.
That's right, but I would expect a fight on that issue.
Right, yeah.
And I guess the one caveat to Norman's answer, I would say, is that I believe the act says that with respect to an individual, you can't put an individual in bankruptcy. I've certainly had a situation where I would have liked to, where I had a what I would call a high net worth guarantor, individual guarantor of debt, and say that person owns plenty of assets and you're aware of fraudulent transfers and dissipation and hiding of assets and other creditors who are owed money by that individual. If you can't drive them into bankruptcy voluntarily, you'd like to have them under a bankruptcy scheme for the benefit of all, but you could go the receivership route with an individual, but you can't, the receiver couldn't then do the two-step of putting the individual into bankruptcy.
And as a corollary to that too, I don't think that getting a receiver appointed for an individual removes that individual's right to file a bankruptcy on their own behalf.
I agree with you 100% on that. Yeah. Okay, well, we have 2 more minutes. Anything else, Haley?
That is everything. So last call for questions. But thank you so much, Lance and Norman. For those of you that are in attendance today, following this webinar, you'll be sent an email with a recording of this session. Please save the date for our 3rd and final summer school webinar on Wednesday, August 17th, also at noon. Warden Smith appreciates you taking the time to join us and hope that you are able to take some of the information you learned today and apply it to your organization. Thank you. This concludes today's webinar, unless any objections from Lance and Norman.
Objection. On behalf of Haley and Norman and I, thank you for attending. If anybody has any follow-up questions now or down the road on these topics or any others, you have our email addresses. Just shoot us an email or give us a call. We'll be happy to talk with you in generalities off the clock about any of these issues. We hope everybody has a great summer, and we'll see you soon.
Thank you.